would be a repetition because the notice, the concern is that there's a big difference between a billion and a much smaller number, and that therefore really raises a serious question as to whether there is not only an injustice but a risk that the penalty against Eisenhower was wrongly convicted and may actually be innocent.
Yes, Your Honour. Unfortunately, I'm unfamiliar with that case. However, my submissions will address that the DNA evidence does not he's still included in DNA evidence, and I would like to highlight a few in my submissions why we still believe that he is guilty and that the conviction should be upheld. Your Honours, the matter at hand concerns Mr. Eisenhower's assertion that a miscarriage of justice has occurred. This is not simply a rehearing of the criminal trial facts. However, Mr. Eisenhower must establish that the findings of the trial judge were substantially wrong and that the outcome of the case was not in the interest of justice. Your Honours, this high threshold...
They have to show that the Court of Criminal Appeal was in error.
Yes, Your Honour.
Error is the key that unlocks the door in this court.
Yes.
You're not back in the Court of Criminal Appeal in Queensland. You're in the National Final Court. Therefore, error has to be shown.
Yes, Your Honour.
They say the central error is the evidentiary error, the big difference between the figures that were placed before the trial court and the figures that would be available to be placed before the jury on a retrial.
Yes, Your Honour.
It was a pretty good argument.
We submit that a miscarriage of justice requires a substantial threshold and that this cannot be established under the submissions.
The difference between a few hundred and a billion is pretty substantial.
Yes, Your Honour. However, the weight of his guilty plea must be taken significantly.
Anyway, you proceed with your argument.
Thank you, Your Honour.
I have no final view on this matter.
Your Honours, Mr. Eisenhower pled guilty on his own accord to the charge of rape. He is not excluded from having a match based on the DNA evidence, and he had the opportunity to commit the act. Our learned friends have raised the issue under Section 668E, subsection 1 of the Criminal Code, which I may now refer to as the Code of the Honours Commission. The respondent seeks that this court dismisses the appeal and the conviction be upheld. As my learned friends have outlined, there are two circumstances that can give rise to a miscarriage of justice, as established in Nunn and Against the Queen by Justice Leeson. My submissions will address the process, whilst my co-counsels will address my learned friends' issues with the outcome. Your Honours, a miscarriage of justice relating to procedure requires an error in process, whereas a miscarriage of outcome assesses when the verdict reached was unjust.